Welcome to Self-Storage Legal Chat. I'm Carlos Caslow, and my partner in this is
Scott Zucker. Welcome, everybody.
And we're going to basically be looking at some questions that self-storage operators have about operations and sort of the businesses they run. And for the next 30 minutes or so, we hope you get some information that helps you run your business just a little bit better.
Off. What's the hot first topic of the day?
Well, the first topic, Scott, is what do you think about NNN, sometimes referred to as triple net lease?
Well, I understand why the topic has come up in our industry. Our poor operators struggling with higher taxes and higher insurance costs, higher operational expenses. What are they supposed to do when these costs keep escalating? How to solve the gambit between those cost escalations and trying to keep their rental rates down. So I guess that's why this issue's come up.
Well, I think it's a kind of an interesting one because it's never been part of the self-storage repertoire in terms of the acquisition and development of property. Unlike other things, you see it a great deal in restaurants where you have these franchisees that have large numbers of properties, and they're all triple net lease. Probably the largest one in the company is Dollar General. They have thousands of triple net leases. I think all of their stores are run that way. And the one thing to always keep in mind is that ultimately a triple net lease, while it looks like a sale and lease, is actually a financing mechanism. And it's a way that businesses use to keep loans off their balance sheet and have lease liabilities, which handle differently. There are taxation issues. There is a huge body of law in this area because it's been in existence for quite a number of years. And there are just a number of business models that use it really aggressively. It never really caught on, I think, in self-storage because self-storage, when it first started, was always used. It was a lot of people thought of it as a way to bank land. You had this little business that generated a fair amount of revenue. And, but 10, 15, 20 years later, the property will soar in value and we'll put a real business there.
Right. So how would you, do you think it's a good idea for storage operators to think about triple net leases with their tenants? I mean, is it something practical? Is there some sort of maybe a middle ground to deal with these higher costs of taxes?
Well, yeah, the driver is always been the developer. And I think we'll start seeing the wide use of triple net leases when there is a company that wants to use this mechanism as a way not to use up a lot of cash and not to start, having a lot of loan liability as a means of growth. I mean, that's how the most of the businesses that use it, they use it as a growth driver. And so, and the folks that own businesses that own, somebody could decide they're going to use it as a roll-up mechanism, or something like that, where they engage long-term leases with self-storage operators and just operate the business part of the thing. But it's not generally, the landowner is passive. And it would be a way where a self-storage operator could, disengage from the business typically these leases run for, a 15-year initial, 20-year initial term. And then they've got 5-year options at the discretion of the renter. So it's sort of the leasee.
Interesting. But I think we're talking in my mind, I think we're talking a little differently. You're talking in terms of a development opportunity with the user of the land. I'm thinking even more granularly, the operator charging its tenant the rental rate plus what might be considered to be a triple net, having the tenant assume the obligation for the taxes.
I don't think it's practical in a situation where you have 500 tenants. It's
What
just,
about a pass-through?
Would be a nightmare.
Right, but now we're now talking about maybe a square foot analysis per tenant. What about just a pass-through tax fee on top of the rent?
Yeah, my caution is just the sheer numbers. The problem with self-storage, a shopping center, you might have 20 tenants if you're a pretty big shopping center, unless you're one of the mega malls. With a self-storage facility, even a small self-storage facility has 300 tenants. Think about the accounting burden that creates. I don't think it's something that the owner and the tenant can do. I think this has to do with either some kind of, because these are, they're designed to be, 30, 40, 50-year leases in the normal structure. No one has ever come up with a month-to-month triple net lease in my mind.
Right. So let's go back to my original comment as a legal solution for the cost escalation for operators manning their facilities. After what we saw in Florida with the hurricanes and what will be the increased insurance cost, what's an operator to do with facing all of these increased costs, but for necessarily having to raise their monthly rental rate to their customers? Is there any other solution?
Sell to public storage or extra space.
Okay.
I mean, those are real. I mean, if you're gonna, again, if you're gonna stay in the business, and from an operating standpoint, these are considerations that you're going to have to handle directly. And I don't think there's any really clever means that you're going to be able to get around it, because again, if you have a 400 or 500 space facility and trying to do pass-throughs and CAM and all of those kind of things that are endemic within a real triple net lease, because in the normal transaction, there's one tenant and there's one landowner or land building owner. There's not 500 there's not 500 tenants to deal with. So I just don't see it as a practical solution on the on the self-storage operator customer side. I think it's really intriguing though, if some from a development standpoint, because it's never been used in the industry.
Fascinating. Well, I like your answer to the question: when the going gets tough, sell or suffer the consequences on the spread between costs and rental revenues.
Yeah. Well, you brought up a big deal in insurance is becoming a big factor in the industry, but especially in, if you're in certain areas of California, certain areas of Florida, you're looking at, you're scrambling to buy insurance in a lot of instances. Yeah. And that, and that really does start to impact the bottom line. So, yeah.
Frightening stuff. Well, look, I just saw what was happening in California with the fires, the storms in Florida. I mean, there are certain areas that are really subject to risk to build a building.
And that's why when you're in an area like you're in Miami, or you're in some of the areas of California where Marin County, where fire danger is prevalent, and insurers are backing out of the market. It's one of those situations where the large operator, like the Public Storage, the CubeSmart, have an advantage because they're spreading the risk over 50 states, and they're not, you're looking at a single insurance market. They're looking at a much more homogeneous, type of situation when they try to buy insurance. And insurers love big companies.
Yeah. All right, so let's move from costs to potential liability with data privacy protection. I know we got a question recently about the storage of tenants' personal information and how to maintain that, how long they should keep it, how they should delete it. What are your thoughts generally with how about starting out with this? What is what does an operator need to ask for in terms of private information to develop their lease agreement?
Yeah, that is a really interesting question because, and the reason I think it's interesting is because we're moving from a person walks in the door and rents a space and there's a human transaction, and we're moving away from that to electronic transactions where it's often taken place on the phone or something like that. And and in some instances, the tenant can rent a space and nobody ever sees this person. And so the operator, I think, wisely says, well, I've got to have some kind of confirmation of identity. So they're going to ask for things. Obviously, the credit card is, or some other payment method is the, is the entry point. But do you need other things? And operators have, what I'll say is different risk appetites. And, a credit card, if you got a credit card and the swipe goes through, you're in. Others say, no, that's not enough. I'd like some confirmation of your ID, and they might want you to upload a driver's license or something like that. My worry, when we do things like that, is that, is how do you protect that information? How does the operator protect that information from the data breach? And obviously, the starting point is encryption of your data files, because we're no longer putting pieces of paper in. Hopefully, locked cabinets was the security realm. And there's two problems. You're always worried about, external attacks with respect to your data, but but you also have the internal problem, and where do you have a disgruntled employee or something like that who has the codes? So it's a lot more difficult than it was before. And the truth is that if you've got hundreds and especially have thousands of spaces, and you have a company-wide data breach, there can be a big cost to that.
Right. So because of the risk, would you be inclined not to take a driver's license information? I mean, or your point is, if you're going to take it, to just make sure it's protected behind a firewall through the proper encryption, using the proper software to protect it.
Yeah, I do that. And then I would also have a purge. When do I purge information? And there's certain pieces of information that I think you have to keep beyond the relationship. After the tenancy ends, the tenant moves out. But it's not a lot. You want to have a copy of that. You want to maintain a copy of the rental agreement, because that's sort of the fundamental document of the relationship. But do you need this external stuff, like if you were uploading driver's licenses that you wanted during the relationship, or you took this information down? I'd get rid of that really quickly. I think that you want to trim down those files to the things that are absolutely necessary. And the only things that I kind of look at as necessary probably are, the rental agreement and the payment records. And a lot of that stuff doesn't, payment records probably don't have any, necessarily have any personal information. And, the rental agreement might, but again, if you have a way of keeping it, relatively secure, I think you're probably okay. But you probably want to keep rental agreements, for 3 to 5 years, depending on the statute of limitations in the state.
Well, and that question's come up a bunch. How long should you keep records after tenant vacates? And I tend to agree with you. I think certainly that you would keep that file, and it can be scanned. It need not be the original paper file, but keep it pursuant to the state's statute of limitations for how long a tenant has to make a claim. And each state is a little bit different in terms of the duration of the statute of limitations. But I would clearly keep files and keep that data for claims that you've had for loss or damage to a tenant's goods, or as a result of a lien sale. I would always urge operators to keep those files through the whole period of the statute of limitations.
Yeah, I have a question for you, Scott, because you're a litigator and you litigate self-storage contracts. Time to bring suit. How effective is a 1-year time to bring suit provision? Because boy, I only have to keep my information for a year and then I can get rid of it. That would be great.
Yeah, the contractual limitation versus the statutory entitlement is a long time question. Are parties bound to the contractual agreements that they meet, even if the statute would provide them a longer period of time? I mean, unfortunately, I've seen cases go both ways. I don't know if you had a hidden answer in your question, but I would tell you this: even if the contractual limitation was 1 year, like you see in many like insurance contracts and things like that, I would still keep the information through the entire statute of limitations period. I would caveat all of this though with an interesting twist that under many of the privacy acts that you're seeing being passed in multiple states, where a tenant has the right to request that their information be deleted at the end of a transaction. Would you have the obligation to delete the information if there was a pending claim relating to that tenant in your system?
Yeah, I think you can keep legal documents, that are memorialize a business transaction for the statute of limitations. I don't think a tenant or anybody has a right to require you to destroy something like that, because it's fundamental to the business transaction. So, I think I think we want to think about what we do with it. Like, is there a way you can take active information and move it to an archive that has very limited access, both internally and externally? I mean, there are things we can do in the electronic world that we weren't doing when we were dealing with paper documents for the most part. And so, and again, you mentioned scanning, and then scan it and move it to some place where it's warehoused in an environment that is not be very difficult for a data breach or some problem like that occurring.
All right, so I have to have you answer the question that you asked me. So would a contractual limitation on duration of claim rights supersede a statute of limitations provision?
The answer is it certainly can, and I think that what we're really talking about here, it can be a really great defense when people stay over, and it just ends everything because, well, this contract has a 1-year statute of limitation, and this is 18 months out. I'm sorry, your claim is barred. But it's not a certainty, and it's like a release of liability and some other provisions in a rental agreement. If a judge wants to get around it, they got 10 ways to do it.
I like the concept though, and you'll see it in the leases that I prepare, and I think you as well, is the rationale behind a limitations period for bringing claims is a fairness issue. If a business is operating and there's an event that could rise to a claim, and the business prepares itself and controls its information and documents and videos and whatever, and then a claim doesn't come for years pursuant to a 6 or 10 year statute of limitations, but there's a 1 or 2 year period in the contract, I think there's a matter of fairness for how the business is supposed to maintain its files, and the obligation of a person who claims a harm to bring notice to that company that they're going to pursue a claim. I think it's fair.
Yeah, no, I do too. And memories fade, and the more time that goes by, it probably hurts defendants more than it hurts plaintiffs. In my mind, because the plaintiff is the aggressor here, and 5 years later, I don't have any recollection of that transaction because I've done 100,000 since then.
All right, so the third topic on the day deals with leases. And I know this question came up from an operator a tenant was changing spaces, transferring from one space to another. They had signed the lease for the original space, but had not signed a lease for the transferred or new space. So I know the initial question was, how do you feel about the fact that there was not a signed lease on the transferred space? I'll let you give your answer to that one based on the facts of this particular question.
And one more thing occurred, and that was that the tenant stopped paying the rent. And what the operator wanted to do was notice, well, can I go forward with the lien? And fortunately, in this particular situation, the operator had a transfer receipt. So just a little document where they had the tenant, indicate the old space, the space they were moving to and relate, and then they were going to supposedly move into the new space and execute a new rental agreement. And when they brought up the fact that they had this written, this receipt, and that described the move that had taken place, I had no problems with the original lease being in full force and effect for lien enforcement terms. Because it described what happened. So the paper trail that you want to see was there.
Yeah, and actually it's a perfect word for it, paper trail, because you had that transfer form. We had the original lease signed, then the transfer form, and even in the absence of an unsigned new lease, there's a pretty clear determination of intent from the original lease, the transfer document, even with the unsigned new lease, in terms of lien rights and enforceability. So let me push you a little further on that question. And we talked about this earlier with regard to the enforceability of unsigned leases that operators face on a day-to-day basis. Give us a little bit of an update on what's happening with state legislation to solve that problem in some states.
Yeah, just making a statement. This has been a problem in the industry for a while because so many states have requirements, rental agreement requirements for you to enforce the lien remedy. California, Minnesota, Wisconsin. Florida is one of the few states that doesn't have one. I always love Florida coming from California because you didn't have to have anything in the rental agreement. That's another story. But it was a problem because, things happen when self-storage spaces get rented. And for one reason or another, there wasn't a signed rental agreement in the file. And now it's 6 months later and the tenant stopped paying rent. Well, what do I do? And it's still a problem today, but we're starting to see a solution. And the Self-Storage Association has started a legislative effort to actually say that, look, if the tenant was sent a copy of the rental agreement, and failed to, sign it, the owner shouldn't be penalized for that. And it's in the very early stages, but there are 6 states now that have variations on this theme. That if the tenant was given an original lease, or in other instances, if a change was sent out and the tenant never responds, well, is the change effective? And so this area is being addressed statutorily, and Scott is in one of the states that has made this change already.
Right. Yeah, no, Georgia enforced the fact that you could send out a lease or a change of terms and with notice to the customer. And if the customer doesn't even sign the lease, that it's deemed effective as long as they continue to occupy the space post the effective date. And that seems to be a pretty fair approach to the problem. Like you said, it's not the operators. The operator shouldn't be penalized because the tenant refuses to sign the lease that they're sent. So that way, sort of, it creates the strength of the landlord. If the tenant isn't happy with the new terms or with the new lease, they have the full right to vacate and move out of the facility.
Yeah, and I think that's important, because on the month-to-month rental agreement, the tenant doesn't have any long-term obligations. They can move in one day and 30 days later move out. But the operators pretty much, they have a form agreement that the tenant signs, and they're not, and they do need that for their records, and they do need that for just to have a regularized system with all of their customers, and that they can fairly reliable enforcement of the terms and conditions of the rental agreement. And I think that's great. We've done a similar change in statutory changes taken place in California, where if you send out the rental agreement and the tenant for whatever reason just says, well, I'm not going to sign it, but continues to occupy the space, they're bound by the terms and conditions. And I agree with Scott. It's really a fairness issue because, the operators have hundreds of tenants, and they have to be able to sort of understand the rules that are, that govern their facility, just to be able to do business in a rational way.
I'll sort of caveat all of this, though, with the best case scenario for an operator is always going to be a signed lease. And I'm so impressed with the technology that's available to operators now, whether it be an RPost or DocuSign or some other methodology where they can electronically send the lease to their customer and make it easy for a customer to click and accept, as compared to the old days where the tenant would have to come to the facility and either sign the lease or get it in mail and sign it and mail it back. I mean, the sort of the physicality of getting that lease signed, now that you have the electronic ability to get these leases signed. When people ask me, like, what's the best lease you could have, would be a signed lease, whether it be physically signed or electronically signed. And then when you move to this frustration where a tenant is basically occupying the space but refusing to cooperate and sign a lease, that's where these statutes come in, where you have to level the playing field to allow an operator to send the lease to the customer, give them an opportunity to vacate if they don't want to approve it. But if they continue to occupy, they're deemed to have accepted the terms and conditions. That to me is the step below the burden on the operator to pursue an executed lease. Always, best case scenario to me would be an executed lease.
No, I agree with that. And as you pointed out, we're not bound by a single method of paper on ink on paper. One thing about self-storage is it has historically been pretty good about getting signatures on contracts on the rental agreement. And I really found out the truth of that when I started doing some work for a company that was in the mobile storage business, and I discovered that drivers were much less, not nearly as good at self-storage managers at getting signatures. Let's put it that way, because they drop off the contract and the customer was supposed to sign it, and they had a failure rate that was probably in the 20% area. And
wow.
And one of these companies actually had self-storage too, and their self-storage facilities had over 90% compliance. So I had a new respect for the self-storage operators when it came to getting their contracts properly executed, because they did a good job.
Well, those are the old days where people would come into the facility to rent a unit. Now with mobile applications and the ability to electronically sign these things, I don't know. Sometimes it's always amazing to me how some tenants get in the gates to their unit without signing a lease.
Yeah, you're absolutely right. It's always a mystery, and every system, there's always a way around it, it seems like.
Well, here we are at the end of our fourth legal chat. Carlos, you and I have now, as we agreed at the beginning of 2024, would do quarterly legal chats, taking questions that we got from Self-Storage Legal Network members to share with an audience, sort of the legal power hour in legal chats. So here we've finished our fourth one now this year, and looking forward to 2025. Any last minute parting words for our viewers on self-storage legal issues coming into 2025?
Well, I can tell you that the Self-Storage Association is going to have a very active legislative agenda going into next year. They have plans for legislation, I think, at the moment in more than 14 states of various types, most of which is to update the loan laws. But again, they're going to be working on the on issues concerning just abandoned property, or when the tenants they're paying the rent, but you want them to leave anyway, the non-monetary default. So they have a packed legislative agenda. Most of what's going that we know about today is going to be positive for the industry, and there will always be some battles that they're going to be fighting because of one state or another is going to do something that we probably are not real keen on when we operate. If you're operating a self-storage facility, happens every year. The one thing I do want to mention, because I'm very, very envious of my business partner, is he's flying off to Europe next week.
I get to visit your favorite city, Paris. So I'll be thinking about you on the Champs-Élysées as I drink some good French wine. I'll be thinking about my friend Carlos, who usually got to do this every year. So been a wonderful year, 2024, for the Self Storage Legal Network. Looking forward to 2025, and I hope you all have a great holiday. And I'll let you close, Carlos.
Well, yeah, just happy holidays to everybody. And I'm hoping that, 25 is another good year for the industry. It's a little more challenging than when we were in the midst of COVID, when we couldn't keep track, when the space is rented very simply. But right now, the industry's doing well. And I think that most of the operators, while they've got a little bit of headwind out there, are muddling through. And that's one of the things about self-storage. Even when times are difficult, we muddle through, and it's always a good business.
Well said. Thanks, everybody.
Yeah, thanks.
See you in 2025. Thank you all for joining us on the Legal Chat for the Self Storage Legal Network. We want to thank Lighthouse Storage Solutions for producing this with us, with the Self Storage Legal Network. Again, you can ask questions for us for our future sessions that are going to be on YouTube. We're going to do these 4 times a year at the email below. And certainly you can reach out to Carlos and I via our emails if you have other questions about what we're doing. And certainly you can reach the Self Storage Legal Network at www.selfstoragelaw.com. Again, thank you.
Thank you.
We'll see you soon.